The National Assembly, in the exercise of its power under Section 8 and 9 of the 1999 Constitution, which pertains to the procedure for alteration of the Constitution. And in this case, the Senate yesterday considered a number of bills. Over 25 bills were considered. And some of them were approved. Some of them did not scale through. For example, we have the bill on independent candidacy to allow Nigerians to contest election independently without reference to a political party, without having to be sponsored by a political party, which is currently the position. That was approved unanimously. We also had another popular bill, what is termed the Not Too Young to Run bill, which reduces the age, the qualification, and eligibility to contest election into legislative houses and executive positions. For example, the president, the age has been reduced to 35, if I'm not mistaken. The same for the Senate, also for the House of Reps, the governor and the rest. In fact, at 25, one is now eligible when the bill finally, if it scales through, can now contest election to the House of Representatives. We also had other bills which they approved, like the infamous one they called the bill to give immunity to lawmakers. That also was approved by them. They rejected the bill for devolution of power, which is quite unfortunate because that is a bill which one way or the other would have addressed the agitations that we are seeing in the country, the rise of centrifugal forces, where we see agitations in the east by the pro-Biafra people, and even in the west, there has been this call that this system, this so-called federal system, is not workable, and that it is pertinent for Nigeria to redesign its policy, to redesign the structure. That is what restructuring, as some call it, means, or devolution of power. For example, they want to abolish SEC, States Independent Electoral Commissions, to now allow for INEC, or INEC, as some call it, to conduct election into local government councils in the country. That was also approved. And also the bill on financial autonomy for state houses of assembly, a whole number of them. Some of those bills were approved, but I think the most significant one that was rejected is the bill for devolution of power. And the most controversial that was approved is the one to confer immunity on members of the National Assembly.
If this bill scales through, if the bill scales through, is there still another process after the approval of the Senate?
Definitely.
Apart from the presidential assent?
Definitely. Oh. The procedure outlined under Section 9 of the Constitution is very clear. First, of course, each of the houses of the National Assembly, the Senate and the House of Representatives, must concurrently pass each of those bills. After they have passed it, it will now be sent to the houses of assembly for concurrence, and 2/3 of the 36 houses of assembly has to approve each of them, each of those bills. So plus or minus, you are looking at 26 houses of assembly. They have to approve each of the bills that the National Assembly passed. It is after that has been done, it will now be forwarded to the president for assent. So when that has been completed, that is when the Constitution is deemed to have been altered. But of course, this also differs depending on the items sought to be amended. For example, if they were to propose state creation, which I am happy was rejected because I feel there is no need to create states when we already have 36 states in the country that can barely pay salaries, 36 non-functional states. So why do we need more states? So I am happy that was rejected. If it was for state creation, the procedure is more rigorous under Section 8 of the Constitution. So basically that is the procedure. As I said, each of the houses has to approve it. And of course, you can expect disagreements in one word in some of these bills. The House may not pass the version passed by the Senate. When that happens, they will have a concurrence and harmonization process to reconcile their gray areas, after which they will now send it to the State Houses of Assembly.
I know that a lot of Nigerians want to know about this bill that now gives immunity to the Nigerian Senate. So what does this really imply?
I will be careful in my response. The obvious reason being that the content of this said bill is not available to the public. But we can only speak maybe in the realm of conjecture or assume what the provisions are likely to be. What is of note is that this bill is basically seeking to alter the provisions of the Constitution. For example, Section 308 of the Constitution, which caters for immunity within the Constitution. By virtue of Section 308 of the Constitution, only 4 elective officials are accorded constitutional immunity. And these are the president, the vice president, governors, and deputy governors. These are the persons constitutionally guaranteed immunity from civil and criminal proceedings in their personal capacities. So for the Senate to now seek to alter the Constitution, to grant immunity to themselves in the first place is unnecessary, when the advocacy should even be to abolish the existing immunity for the president, the vice president, the governors, and deputy governors. Given the history of this country, we have seen that the immunity has become a shield. It has been weaponized by politicians. It has become an instrument that empowers politicians to steal resources with impunity, to commit all sorts of atrocities while they are in office, and upon the expiration of their tenure, it is always difficult to bring them to account. Look at the cases of the former governors. So many of them. Which of them has been successfully tried and convicted? None. Balang Gilari, who was just convicted recently, his conviction was recently overturned by the Court of Appeal. So this is the situation we have found ourselves as a country, which has clearly showed that even the immunity for the executive has failed. So why should the National Assembly be embarking on this kind of self-seeking, this kind of selfish agenda, when we already have a law in place to give them immunity when they are acting in their official capacity, which is the Legislative House's Powers and Privileges Act. There's already an existing act of the National Assembly that gives immunity. Section 3 of that act gives immunity to the members of the National Assembly and the Houses of Assembly from suits, from litigation, when they are acting in respect of comments they make in the course of their duty. For example, you cannot charge a senator or a House of Representative member for incitement or for any offense in respect of comments he makes in the course of proceedings in the Senate or during oversight in committees. There's already a law that caters for the so-called mischief that they seek to cure. If there's already a law which has been shown to be effective, because I'm not aware, as a student of constitutional law, I am not aware. I cannot find any precedent in our law books, that a member of the National Assembly was arrested or prosecuted in respect of comments he made in his official capacity. I'm not aware of one. So why do we need another provision in the Constitution to give further immunity to the members of the National Assembly? My thinking is that this bill is precipitated by the trial of the Senate President before the Code of Conduct Tribunal. This is what has now propelled them to embark on this self-seeking agenda, which is totally unnecessary because they don't need it. What do they need the immunity for? They don't need the immunity. There is already a law, an act of National Assembly, that protects them when they're acting in their official capacity.
I was going sometime in the past, I was interacting with a senior lawyer, and then he made comments about certain amendments to the Constitution about the fact that a former public office holder who's been indicted can now vie for elective offices. He gave me the section that was amended, but I don't have it here. So let's talk about this devolution of.
Well, just to intervene on that, okay. The issue of indictment had been settled by the Supreme Court in the case of Alhaji Atiku Abubakar, an Attorney General of the Federation, where the Supreme Court decided that, notwithstanding that indictment by judicial panel of inquiry is one of the disqualification indices under the provisions of the Constitution, which disqualifies any person who has been indicted by a Judicial Commission of Inquiry from contesting election. The Supreme Court has said no, that pronouncement of guilt can only be made by the court. And until the court has pronounced the person guilty of an offense, of a criminal offense, that person is eligible to contest election. So this is a no issue, if you ask me, because it's an issue that the Supreme Court, the highest court in the country, has resolved.
Let's go further to the devolution of federal power. What does this really portend?
Section 2, subsection 2 of the Constitution states that Nigeria shall be a federation consisting of states and the Federal Capital Territory. That is the starting point. We also have the relevant sections and provisions of the Constitution, specifically the second schedule. Part 1 of the second schedule contains or has what we call the exclusive legislative list. I'm trying to break this down so that Nigerians who misunderstand what devolution of power or what restructuring entails can really know that this is not a spiritual exercise. This is not some complicated matter that, if embarked upon, will split the country. It's a misconception. It is a wrong argument, a terrible narrative that has been raised and propagated over time unchallenged. So it is important to state and set the record straight. If we examine the Constitution of Nigeria, the second schedule, Part 1 and Part 2. Part 1 contains the exclusive list. Part 2 of the second schedule to the Constitution contains what we call the concurrent legislative list. Under the exclusive list in the second schedule to the Constitution, there are 86 items. Under the concurrent list, there are about 12 items. What that means is that by virtue of Section 4 of the Constitution, on the legislative powers of the Federation, Section 5 of the Constitution, on the executive powers of the Federation, and Section 6 of the Constitution on the judicial powers of the Federation. If you look at the items, the 68 items under the exclusive list, it means that only the National Assembly can legislate on any matter that is so listed, and only the executive can formulate policies or execute laws enacted by the National Assembly pursuant to its legislative powers under Section 4 and under Part 1 of the second schedule. How can you have a federation where the center, the federal government, will be exercising over 90% of the powers of the government of the country, and the states are left handicapped? And note that even the matters listed under the concurrent list, the federal government also has powers over that matters. Those matters are not exclusive to the states. That is why it is called concurrent list, meaning it is concurrent to both parties. And the states are left to be running to Abuja at the end of every month for salary, running to Abuja for subvention, running to Abuja for grants, running to Abuja to basically maintain the government at the state. This is totally unacceptable. Why do we have prisons under the exclusive list when states are the one even running these prisons? Go to all the prisons that you know. You can go to Kirikiri, go to Ikoyi prison. They are in a total state of disrepair because majority of the convicts and awaiting trial inmates, they are actually in prison based on offenses enacted by the states, based on laws enacted by the states. No federal offenses. There are very few offenses that are tried at the Federal High Court. Most of the criminal offenses and criminal trials in Nigeria are even resolved at the Magistrate Court, which totally belongs to the states. When people hear restructuring, when people hear devolution of power, what really comes to mind is that, oh, this is about revenue sharing formula. This is about how to share the national cake. For example, some people are advocating for state police. Why I have issue with the working of the police, and also in principle not opposed to state police, I also have reservation about creating police force governors. That will basically amount to giving them official militias, which is what they have turned even the federal police to. They have turned it to political talks. Police now serve the interests of politicians.
Now that the Nigerian Senate has rejected the devolution of federal power bill, what's the next step?
Well, I believe that they are merely postponing the evil day. That is what they have done. The reality remains that this so-called federalism, which in reality, in the real sense of it, is a unitary system that was foisted on the country by military buccaneers. If we revert to the 1960 Constitution, the Independence Constitution, which worked for us, we did not have this kind of scenario. So I believe that no matter the ethnic, the tribal, the religious arguments against restructuring, eventually as a country, it is an issue that we will have to address. There is no need postponing it. There is no need pretending that we don't need it. We need restructuring. We need it, not just political restructuring, but economic restructuring, like Mr. Femi Falana has called for. We have a situation where private individuals are owning oil blocks. Where someone like General Danjuma came out to say he does not know what to do with money. I believe that if we restructure the country politically and economically, we will see a cease, or at least a reduction, in the agitation for the split of the country.